Hi everyone, and welcome to week 3 of Reproduction and the Law, and welcome back to my kitchen, which you can once again see behind me. We spent the last 2 weeks talking about the legal progression from the pre-Roe days to Roe to Casey and the effect on specific populations such as incarcerated women and young women. And we also spent some time discussing the change in the legal standard from Roe to Casey. As you recall, Casey abandoned Roe's trimester framework in favor of a viability standard, dividing pregnancy into pre-viability and post-viability of the fetus. And the court said that pre-viability states could regulate abortion so long as it does not pose an undue burden on the woman seeking an abortion. So this undue burden standard is now the standard the court uses to evaluate abortion restrictions. Only if a burden is undue will the state restriction be struck down. The court defined undue burden as placing a substantial obstacle in the path of the woman seeking the abortion. This week I've had you read Gonzalez v. Carhart, decided in 2007 by the Supreme Court. I'm sure many of you remember the political wrangling and debate when the act was passed in 2003, and again when the court came down with this decision in 2007. The headline from the case is this: the court upheld the partial birth abortion ban, so it is now the law of the land. What's striking about it is that the court upheld the ban without a health exception. This marked the first time that the court has upheld an abortion ban that did not have a health exception. When you read this case, I want you to think about whether this case in the decision can be squared with Roe, Casey, and Ayotte, 3 decisions that all held that a health exception is mandatory when there is a ban on abortion. So think about whether these cases can be squared with the court's most recent decision. I also want you to take some time to think about some of the other issues in the case. 1, after reading the case, can you define for me what a so-called partial birth abortion is? We know that that's not actually a medical term. It's the term that Congress gave to a specific abortion procedure. But are you able to define what that abortion procedure is? Secondly, are you able to define whether the ban applies pre-viability, post-viability, or both? If you decide that it applies pre-viability or both to pre-viability and post-viability, how do we square that with Casey and Casey's viability standard? So I really want you to be focusing on whether Gonzalez v. Carhart is a logical extension of previous precedent or a break from previous precedent. Also spend some time reading Justice Ginsburg's dissent. She took the unusual step of reading it from the bench, which is a justice's signal that he or she sharply disagrees with the decision of the majority. It's not something that justices do often, so when they do read a dissent from the bench, you should pay attention. So take some time to read her dissent and figure out who do you think got the better argument, the majority or Justice Ginsburg and the other dissenters. Another progression we're going to talk about this week is the progression of technology and scientific research, and more specifically where progressions in technology and science collide with reproductive rights. I'll give you an example. At the time Casey was decided in 1992, viability was hovering roughly around 25-26 weeks of pregnancy. Now, as you've seen in the news, viability is sometimes as early as 22 weeks in pregnancy. With the scientific stage of fetal viability becoming earlier and earlier in pregnancy, does the viability standard established in Casey need to be re-examined? Another example to think about where technology and reproductive rights might be hitting head-on is the issue of the fetal pain bill I had you read this week. That bill, if it became law, and it has not yet, would require that doctors inform women seeking abortions after certain points in pregnancy that it's possible the fetus could feel pain during the abortion procedure. A lot of issues with this bill. 1, there's a lot of medical uncertainty about whether and when a fetus could feel pain during an abortion procedure. Is it 18 weeks? Is it 22 weeks? Is it 26 weeks? When does that actually happen? How do we legislate in the face of medical uncertainty? 2, think about whether we want the state or the federal government to be in the business of telling doctors what they have to tell their patients. Is this a good thing? Is this area so fraught with controversy that women need to be informed of information they might not otherwise know? I think the vast majority of Americans have no idea when a fetus can begin to feel pain. On the flip side, should we be leaving this to a doctor's discretion to decide whether to discuss this with his or her patient? So a bunch of thorny issues here. Another issue where technology and reproductive rights are hitting head on is the Octomom. We think of her as on the cover of People magazine. She looks like Angelina Jolie, but her case raises really interesting issues. She was implanted with 6 embryos, and as you read the literature for this week, you'll see that medical organizations never recommend the implantation of that many embryos, especially in a woman of her age and her health. The question then becomes, if medical organizations are recommending against this, it's one thing. But should local, state, or federal governments be getting involved in the act here? Should we be penalizing or criminalizing doctors who implant more than the recommended number of embryos? And if we do, how do we do that? How do we determine how many embryos should be implanted? Who gets to make that decision? Are we going to deem certain women more worthy, quote unquote, of having fewer or more embryos implanted? Who makes that decision? Who do we want making that decision? And is that a decision we want the government involved in? This week I also had you read the Unborn Victims of Violence Act. This act, as I'm sure you have gained from the reading, would make it a crime to harm a pregnant woman. But here's the rub. It doesn't just make it a crime to harm the pregnant woman, it makes it a crime to harm the unborn fetus. And to be clear, this bill is law. This is the federal law of the land. So, for example, if a person murdered a pregnant woman and both the woman and the fetus did not survive, that person could be charged with a double homicide. The question is, how do we square this with our abortion jurisprudence? The court made very, very clear in Roe that a fetus is not a person pursuant to the 14th Amendment. And indeed, that has to be so for abortion to be legal. If the fetus is deserving of 14th Amendment protections, an abortion would automatically be murder. So how do we square the court's clear statement in Roe that a fetus is not a person under the 14th Amendment with the Unborn Victims of Violence Act, which would make the harm to a fetus or the ending the life, for lack of a better word, of the fetus, a federal crime such as homicide? How can terminating a fetus's ability to thrive be murder in one circumstance and legalized abortion in another? How do we square those two? So as you do the reading this week, I really want you to be thinking about, one, the progression the court has made from Roe up to Gonzalez versus Carhart, and two, thinking about how we deal with advances in technology and science when they come face to face with reproductive rights. Good luck.